Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Well, we're going to head out to the state of Colorado. It is December 19th. Huge news out of the state today, and it has everything to do with guns and marijuana and nothing to do with President Donald Trump. Oh, yeah, you guys thought I might be clickbaiting you here. No. I'll connect the dots for you here in a second. Now, we're not going to touch the other issue in Colorado with the 10-foot pole. I have some very strong opinions, but we are Washington Gun Law, so we're going to stay in our lane today. What I am talking about, however, is a feverish push by a legislative group in Colorado to address an issue that we have addressed multiple times here on the channel, which is, why is it that the town drunkard can go out and get a gun anytime he wants, but if somebody wants to smoke a joint once in a while, God forbid, they are never allowed to arm themselves? Well, there is a group in Colorado that wants to do something about it. Colorado was one of the very first states to legalize cannabis, and shockingly, they have not fallen apart at the seams because of that. This group has an interesting name. They have even a better purpose. And so let's talk about what they're trying to do. So today, let's spend a few minutes. Let's head out to Colorado and let's talk about guns for everyone in Colorado. Okay, so we're heading out to Colorado today to talk about the big issue that nobody's talking about in Colorado because they're all talking about another issue. However, Dateline, December 19th, the group Guns for Everyone, a legislative action group, has met with the Colorado State legislative staff to discuss their attempts to put an initiative on the ballot that would radically change Colorado gun laws so that individuals who are recreational cannabis users will still be allowed to get a Colorado concealed carry license. You see, one of the leaders of Colorado Guns for Everyone, Edgar Antillon, actually met with the state legislature and then was quoted in local paper as saying, "It's really a freedom issue. It's one of those silly things that's been going on for a while. We've legalized marijuana, but we don't give users the ability to defend themselves. Alcohol users get to defend themselves. Why not marijuana users?" And Edgar, that is an excellent question. Now, as we know, under 18 U.S.C. Section 922, which is subject to constitutional challenges now in the Daniels case, United States v. Daniels, which we have already talked about, and is before the United States Supreme Court pending a petition for certiorari. But under federal law, if you are a user or an addict of a controlled substance, including marijuana, because under federal law, cannabis is still a controlled substance, even though you live in Washington, you live in California, you live in Oregon, Colorado, like this case, Nevada. There's many states that have now legalized cannabis. Yeah, if you're a cannabis user, but you answer question 21 correctly, saying, well, yeah, I use marijuana. Yeah, no bueno, sale is over. Now, this has obviously created issues where you had kind of this cross-reference where people in some states went out and got medicinal marijuana cards but also had concealed carry licenses. That too, no bueno, that can land you in trouble. What we've always said here at the channel is that, listen, first of all, I recognize there's a large recreational community for cannabis. I candidly don't have a problem with it. I view that the same way as the recreational industry as it relates to alcohol. There is, however, a segment of population that are using cannabis for legitimate medicinal reasons. And you talk to any doctor who has any understanding of addictive medicine, and they will tell you that if you're managing chronic pain either through cannabis or through opiate-based painkillers, yeah, it's a pretty obvious choice. So why then, for those folks, do they have to make a decision between, exercising their right to actually gain the health care that they need and to be private in their health care is guaranteed under the First Amendment versus exercising their Second Amendment right of self-preservation? Now, Guns for Everyone is going to have to go out and gather 125,000 signatures before this can get on the ballot. However, if it gets onto the ballot, a new section to Colorado's concealed carrying licensing statutory regime would be added, which would state the following: a sheriff shall not use a permit applicant's lawful use of marijuana as a basis for denying the applicant a permit. Currently, the way the law is set up is if a person answers that in the affirmative, or if law enforcement has a basis to know that, they cannot issue them a concealed carry license. This law would exempt that as a disqualifying offense. As the folks for Guns for Everyone stated, people who consume alcohol are able to buy guns and are able to get their permits. But at the same time, Legally, they cannot be under the influence of alcohol while possessing a firearm, and pot users kind of want the same thing. And that is exactly what the historical precedent shows us, because now under the Bruin test, when we go back and we ask ourselves, hey, as a society, do we have historical analogs that show that we accept these types of restrictions? We clearly have restrictions against possessing or using firearms while you are actually under the influence of any kind of intoxicating substance. But we have absolutely zero historical restrictions that an occasional user means that they are barred from arming themselves throughout the duration of their life. Now, this is going to be really interesting because the state of Arkansas recently did something quite similar. And what they did is they set up their own independent background check system so that they could establish whether or not an individual qualifies for a concealed carry license in Arkansas. The ATF, though, has grown a little tissy fit over the whole thing and has sent a nasty, nasty little letter to the state of Arkansas demanding answers because right now they are considering pulling the Arkansas background check system as an approved NICS alternative, which means under federal law, they wouldn't be able to conduct any type of firearm-related background checks through that system. The letter from the ATF to the state of Arkansas stated, "This letter is to inform you that the Bureau of Alcohol, Tobacco, Firearms, and Explosive has public safety concerns regarding the administration of Arkansas's Concealed Handgun Carry License, the CHCL. The CHCL is currently recognized as an alternative to completing a background check through the National Instant Criminal Background Check System, NICS. ATF is concerned that the issuance of CHCLs to individuals who are prohibited by federal law from possession of firearms creates an unacceptable risk of placing firearms in the hands of prohibited persons. In particular, Arkansas state law may provide federally prohibited medical marijuana users the ability to obtain a CHCL issued by the Director of the Division of Arkansas State Police. The CHCL can then be used to acquire a firearm from a federal firearms licensee despite the federal prohibition and without an additional background check being conducted at the point of sale." And then, of course, the ATF has to remind the state of Arkansas that a long time ago, they already passed judgment on medical marijuana users as dangerous people who cannot arm themselves, as they put in their demand letter. Additionally, ATF has provided information to the public on the use of medical marijuana. In 2011, ATF sent an open letter to all FFLs advising them that regardless of whether his or her state has passed legislation authorizing marijuana use for medicinal purposes, marijuana is a Schedule I controlled substance, and therefore a person who uses or is addicted to marijuana is an unlawful user of or addicted to a controlled substance and is prohibited by federal law from possessing firearms and ammunition. So listen, I want to applaud the folks at Guns for Everyone in Colorado there. I think they are doing fantastic work. I wish you well on your signature gathering, and if you need any help, don't hesitate to reach out to Washington Gun Law. This is an issue that we've very strongly been vocal about, which is it makes no sense that the town drunkard or the person who's absolutely strung out on opiate-based painkillers all the time can walk into a gun store and walk out of there after applying through all the statutory requirements with a firearm, but the occasional person who smokes a joint, no, your life is not worth preserving. Listen, if you have any more questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now. If you don't, that's okay. That information is right down there in the description box. Now, in the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.